I'm not saying I didn't do it.
You don't expect me to buy that line of bull, do you?
Just
Do you? Do you really?
Next voice 1. Hey guys, and welcome to today's video. We've got several cases to cover, starting with a dangerous defendant in Michigan who apparently doesn't understand what it means when the judge orders him to stay away from the alleged victim in the domestic violence case against him. Quick interruption from future editor Skeptic here. I came across a courtroom clip yesterday that was just too good to leave out, so I added it to the end of today's video. It comes from Judge O'Donnell's courtroom, and trust me, it's absolutely wild. I won't spoil what happens, but here's a quick preview.
Wald versus Mass Mutual is being called out of turn, and the appellant has submitted a video for his argument. Okay, we will hear that video now.
May it please the court. I come here today a humble pro se
right.
before a panel of 5 distinguished justices.
Is this, hold on. Is that counsel for the case?
I generated that.
I'm sorry?
I generated that. That is not a real person.
Okay, it would have been nice to know that when you made your application. You did not tell me that, sir. I received the application. And you have appeared before this court and been able to testify verbally in the past. You have gone to my clerk's office and held verbal conversations with our staff for over 30 minutes. Okay? I don't appreciate being misled. So either you are suffering from an ailment that prevents you from being able to articulate, or you don't. You are not going to use this courtroom as a launch for your business, sir. So if you are able to shut that off, if you want to have oral argument time, you may stand up and give it to me. You have 5 minutes.
But first, we're kicking things off with what might be the most ridiculous thing I've ever seen in an appellate courtroom, an AI-generated avatar pretending to argue a case as an attorney. We're starting with the artificial intelligence, which is probably half as intelligent as the average person and still somehow twice as convincing as the individual it's representing. With that out of the way, let's jump right into it.
All right, I'm Magistrate Garwood. I'm going to be handling your case today. I'm told that you did not want to speak with the public defender.
No.
So, in this circumstance, at arraignment, everyone has the right to have counsel present to assist them for your first court appearance.
Okay, that's why I didn't need anyone to defend me, because it's my first court appearance, because there hasn't been any problems.
Okay, but it's your first court appearance, and today the court's going to advise you of your rights. Okay. I am going to go through the charges with you so you understand what you've been charged with. I'll give you your next court date. I would appoint counsel if that's something you would like the court to do. That would be at little to no expense to you. And then I have to decide what to do as far as bond and bond conditions. Conditions are things the court tells you can and cannot do. If you violate a condition, you're subject to immediate arrest. The amount of your bond, that's whether you have to post something in order to be released. That's an evaluation I'm going to be making today.
Okay.
So are you sure you don't want to talk to Ms. Anderson? She's an attorney. She's been an attorney for a really long time. I'm guessing you're not an attorney.
No, I didn't break any laws, and I've never heard.
Well, you've been charged.
I've been charged falsely, though. I have already called the police several times and explained this whole situation. Just like Haniel has called the police and explained that I look like her ex that hit her.
Okay, so here's the thing. First, I'll advise you of your rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. So you're going to want to be careful about what comments you make. Second, you have the right to an attorney. If you can't afford an attorney, the court will refer you to the local appointing authority. In that circumstance, Ms. Anderson would assist you today, and then the public defender would be able to assist you going forward. You also have the right to a trial. At a trial, a jury or a judge would be able to decide whether you're guilty or innocent.
Okay,
This is
so-
case YPD 25-6642. So would you like to reconsider and speak with Ms. Anderson?
Before I make a decision, is whatever I choose, is it gonna be a reason for me not to be able to go home and get out today? I understand whether I want an attorney or
So
not.
an attorney is not going to hurt you at this point. An attorney is going to help you at this point because they understand the law and they understand the right arguments to be making regarding bond. I can tell you the prosecutors are requesting a cash bond. So they're requesting that you have to post $25,000 to be released from jail. So it's probably going to help you if you talk to the public defender. If you don't want to, I can't force you to talk to her, but she's here.
And if I don't, then I won't be able to get out without a $25,000 bond.
Well, you'll have to make your best arguments on why I should release you.
Okay.
So what do you want to do?
I'll say what I can say for it to be released. I don't need somebody else to say it for me. I mean, I know the law too.
You know the law.
Yeah, I'm not a lawyer, but I went to high school.
You and every other lawyer out there. The only real difference between the two of you is about 6 extra years of legal education, 6 gallons of bad decisions, and a few too many head-first meetings with the staircase when you were a baby. Other than that, you could practically be identical twins.
Okay. All right. So I've advised you of your rights. The complaint in this matter alleges that on or about May 24th of 2025, that you were at 201 North Huron Street in Ypsilanti. The single charge alleges that you did make an assault or an assault and battery upon Hanel Groshusch, Grossushuesch, an individual with whom you've had a dating relationship. That is a misdemeanor charge. It carries a maximum penalty, 93 days in jail, and or $500. Do you understand what you've been charged with?
No, because this charge is false. It's not.
Okay, hold on. That's something
I never
different.
put my hands on it.
Hold on. That's disagreeing with the charge. Do you understand what you've been charged with? I understand you're saying you're innocent. It wasn't you. You didn't do it.
Okay.
But for today's purposes, you've been charged with this crime. So do you understand what that crime is? Or do you need me to go back
I
through it?
understand what you said, but I'm just saying it's false.
That's fine. So you understand what you've been charged with. Do you understand the maximum penalty?
Yes.
All right. I'm going to have you stand mute. That means you'll remain silent as to the charge. I'll enter a plea of not guilty on your behalf. I'm going to schedule you for your next court date. That's going to be a pretrial that will be in person in front of Judge Barr. He will be able to see you on June 5th at 9 a.m. at the 14A2 District Court. Yes.
The problem is I still have 4 daughters and bills to pay. I need to be able to go to work. How am I gonna?
We're not there yet. I'm just giving you your court date.
Okay.
Okay. So in person at the 14A2 District Court, June 5th at 9 a.m. in front of Judge Barr. We'll send you a notice to appear at the jail. The next thing we'll need to address is bond. There are 2 parts to bond. Bond conditions, those are things the court tells you can and cannot do. If you violate a condition, you're subject to immediate arrest. The other side of bond is whether you can be released today on your own or whether you'd have to post a bond in order to be released. Before I make any decisions regarding bond or bond conditions, I will hear from Ms. Landy, who I think you still need to put your appearance on the record. And then I'll be happy to hear from you. But again, I want to remind you, anything you say can be used against you and you do have the right to remain silent. Ms. Landy, your bond arguments?
Thank you, Your Honor. Ashley Landy for the people in this case. Your Honor, has the court had the opportunity the court took the swear to in this case, correct?
Yes, we did that this morning.
Thank you. Your Honor, I am requesting a cashier surety bond. I am also further, I believe, requesting a GPS. I have to pull up my notes here. In this case, the allegations include the defendant remaining in the victim's home not leaving when being asked to leave, going into her bed and touching her under her clothes. The victim did not provide additional details for us to be able to look at charging a CSC in the 4th degree. However, there is sufficient evidence to charge the domestic violence, as they had previously been in a domestic relationship, a dating relationship. So I am requesting a $25,000 surety bond, as well as a GPS tether to keep him out of that 201 North Huron Street
There's never
address.
been.
Sir, you do not get to interrupt me.
It is not your turn to talk, and
Oh.
you're not going to interrupt anybody.
Sorry.
Ms.
So
Lund.
I'm extremely concerned for her safety. This is a very disturbing fact pattern and a disturbing case. I'm also requesting that there be a prohibition against the defendant possessing firearms as a component of his bond, as well as standard supervision at community corrections. And that $25,000 cash or surety bond, I request it be no 10%.
At first, when I heard the recommendation of $25,000 cash or surety bond with no eligibility for the 10% provision, I thought it seemed a little excessive. Then he was given the chance to speak for himself, and by the time he finished, I started wondering whether even that amount was high enough.
All right, now, sir, you will be able to make your bond arguments, but again, I want to remind you, anything you say can be used against you.
Okay, I have permission to speak now?
You do.
But okay, so what I'm saying is, me and Haniel have never been in any sort of violence whatsoever. Not even one time. And she's called the officers before and explained that has nothing to do with me. So because I don't understand why is all this necessary? Because the last time I called the cops and had a welfare check done on her because she wasn't answering, I was worried about her, and the cops came and arrested her. So why is all this information just gone? Nobody knows, understands. They're not helping. They just come and try to accuse us of hurting each other, but it's others that's hurting us and taking from us.
So you do have a criminal history. I mean,
No, I don't.
what's your date of birth?
No criminal history.
So you pled guilty to an assault and battery.
Yeah, because they said I have kids and house payments and responsibilities to take care of my family. And how am I supposed to do that being in jail for months to be able to go on trial?
Pled guilty to attempting to assault, resist, or obstruct a police officer.
Yeah, I know. I had to because I didn't need to be in jail where I can't even take care of my family. That's the reason.
Well, regardless of why you did that, you have a criminal history. That's just the fact of it.
I would never hit a woman anyways. I never said I wouldn't leave. But I said I was leaving. She's told me not to leave until you guys got there, so she knows I'll leave because other people that she's been with, because she dated several guys that look like me, because that's who's just her preference, I guess. But I've never told her I would not leave. I would not do that. I don't want to be somewhere I'm not wanted. She wanted me to come there. I said I can't stay here.
I would encourage you to stop talking. Because now you're talking about what allegedly took place on that day. If you can keep talking, but you may make the prosecutor's case for them by saying what you're saying.
I told her that I can't stay until until the police come, because even if I do, they're just gonna arrest me because you already know that I'm not supposed to be here. How is she gonna let me? I only went there to give her money. I gave her money when I went there.
Pay close attention, everyone, because he's about to deliver a masterclass on why you should let your attorney do the talking and why exercising your right to remain silent is often the smartest decision you can make.
Okay, so now you've acknowledged that you were actually at the property. So again, I'm going to encourage you to stop talking. Is there anything else you want to say before I proceed with your bond conditions and bond amount?
No, that's all. I was saying, I'm sorry. She probably was just having a bad day. It's not. I would never hurt her. I love her. I love her with all my heart. I care about her.
Okay.
If she's sick, I go get her medicine or ask her if she wants something that would make her feel better. Or say I'll get whatever she needs that to be happy or
Okay.
feel
I'm gonna
comforted.
I'm going to have you stop talking because again, you are saying things that I do not think are going to help you in this case. Your bond conditions are as follows. You're going to be required to have standard supervision at our community corrections department that will include drug and alcohol testing. Each time that you are required to test, you'll have to bring photo ID and $12. If you don't have photo ID, then you'll be able to ask the jail for a copy of your booking photos. No alcohol, no illegal drugs, and no marijuana. Do not leave the state without prior permission of the court. Do not purchase or possess any firearms, ammunition, gun components, or any dangerous weapons, nor are you to be with anyone who has any of those items. Do you own any of those types of items?
No.
Do you understand your conditions so far?
Yes, but am I allowed to say anything else?
I'm not done.
Oh, okay.
Do not assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. Do you understand?
Yes.
You're to have no contact with, when I say no contact, no direct or indirect contact with her, no telephone, email, texting, internet, or social media, Skype, Zoom, FaceTime, Facebook, Slack, Discord, Instagram, Snapchat, TikTok. No contact means no contact. Don't direct anyone else to be in touch with her on your behalf. Don't mail anything to her. Don't deliver anything to her. Don't have anyone else do what you're not allowed to do in reference to contact with her. Do you understand?
Yes, of course.
You are not to go to Huron in Ypsilanti. If that is your home address, you must find another place to live and you must notify the court of your new address within 24 hours of your release from jail. We will give you a phone number that you can contact. If you need to return to that address for a civil standby, you'll be allowed to do that. A civil standby allows you to contact the police. They would meet you there. They are there to keep the peace. That is not an opportunity for you to hang out. That's not an opportunity for you to communicate with Hanel. That's just an opportunity for you to get your things and go. Do not go without the police. Do not
Okay.
go to any home, temporary residence, work, school, or house of worship of Hanel. Do you understand?
Yes.
Do not violate any criminal law. You're required to appear for any and all court hearings and other places as directed by the court. All of your conditions, they will exist whether you're in custody or out of custody, and they'll remain in full force and effect until changed by the court. If there's any change to your address, email, or telephone number, you're required to notify the court. If at some point you change your mind and decide you want the public defender to assist you, you would make the judge aware of that, and then the judge can make a referral. Do you understand?
Yes, ma'am.
Do you have any questions regarding your conditions before I set the bond amount?
No, can I say one more thing?
I don't think I could stop you.
Okay, so I just want to know, so as long as I don't go there, even if she tells me to go, so then there won't be no problems between us?
Dude, you're still not getting it. Do not go anywhere near her under any circumstances, and there won't be any further issues. In situations like this, the court's priority is protecting the alleged victim, which means that until the case is resolved, you're prohibited from contacting her in any way, whether it's in person, by phone, through text, social media, or anyone else. Violate that order, and you'll likely find yourself right back in jail. And judging by what you just admitted in open court, you've already managed to make things worse by acknowledging conduct that could create even more legal problems, while also demonstrating that you either ignored or completely failed to understand the court's orders.
You can't have contact with her. It's not
No,
just.
I know, I understand, but
Yes.
she's the one that called me to ask me if I'm okay.
Again, I encourage you to not talk about what specifically happened on the day.
Tell me I have mail or.
See, this is a good time when having an attorney would be useful to you because you could ask those questions of your attorney.
Okay. So as of now, based on what I told you what happened, is there any way I will go home, go like to one of my relatives' house today?
So you're welcome to post the bond that I'm about to tell you about, and then you can go home to a relative's house. So this is what the court is going to do. Based upon the facts that are alleged in this case, it's of concern what was presented to the court. potentially additional charges could be coming from how I heard the testimony. I am going to set a cash bond in this matter. That is going to be $10,000 cash or surety, no 10% privilege. I believe that is appropriate in this case.
Can it be a personal bond?
That's not a personal bond. You would have to post $10,000.
So why is that?
And I am going to require the defendant to have a GPS tether to make sure that he doesn't go back to that address prior
There's
to
no reason to go
release.
back to that address. I never said I wouldn't go back, not go back.
I'm going to have a GPS tether placed on you. They don't place tethers on holidays or weekends, so that tether would not be placed until Tuesday.
I just don't understand why am I being ignored? She has a mental disability.
I'm talking. I'm not sure what's so
I'm
complicated.
not
about
mental
it.
health or drug addict or anything, so why are you guys saying this?
All right, I'm going to mute you if you keep interrupting me. So the tether can't be placed on the holiday or weekend. The tether would be placed on Tuesday. That's the next time the agents are here.
I have work Tuesday. Why you guys want to make me lose my job or something?
I'm not making
I know
you.
that's necessary. It's the holiday weekend.
So because it's a holiday, if somebody commits a domestic violence, it doesn't count?
If somebody makes a false accusation because I look like one of her exes, it's not up to you guys to do a proper investigation and get more proper information from both of us.
Again, an attorney would be most helpful.
Somebody that doesn't have a mental health condition.
So
or
your
even-
bond, hey, I'm not
Direct
deciding
argue.
guilt or innocence. I'm just deciding what bond conditions are necessary to keep everybody safe. You've demonstrated to me an inability to control yourself because you keep interrupting me, which is rude and inappropriate in this circumstance. You did it to Ms. Londy as well. So I have to consider your ability to control yourself and follow my court orders. And that gives me concern that you can't do that either. So the bond is going to stay $10,000 cash or surety and a tether prior to release. Ms. Londy, anything further?
No, Your Honor.
All right, you're all set, sir. You can stand up and go to the door. Thank you.
At this point, he should simply stand up, leave the courtroom, and start working on whatever arguments he wants to make in support of a bond reduction. Instead, he decides to stick around and somehow make an already bad situation even worse for himself.
So there's no way I get to go home unless I pay $10,000.
Right, and get the tether, and you can't get your tether till Tuesday.
So even what if I don't have $10,000
Then you'll remain in custody until your next court date, which is June 5th at 9 a.m. So that is next week on Thursday.
And that's because I said I wasn't guilty. How I don't understand.
Of course not.
Yeah,
That has nothing to do with whether you said you were guilty or not. That has to do with.
I spoke out of line, but I didn't raise my voice.
Do you want me to answer your question, or do you want to just keep interrupting me?
Nothing wrong.
Do you want me to answer your question, or are you just going to keep interrupting?
What am I interrupting? Nothing I said is stopping you from understanding my side of what's going on. Or
If every time I talk, you start
listening to
talking
you
while
or
I'm
being
talking.
disrespectful or nothing. I didn't mean any disrespect towards you or anybody.
Okay, well, here's the thing. The allegations that have been presented.
I understand what you're saying, but I'm not ignoring you. I'm not trying to speak out of line.
Then why do you keep talking while I'm talking? We're done. The allegations that were presented to the court give the court concern about the safety for the victim.
What about my safety?
I'm done. We're
And I
done.
told you guys, or I had called before.
You're muted. We're muting you. You've been muted. You can go to the door. You can go to the door. We're all set. I can't hear you. You're muted. So you can stand up and go to the door.
All right, so that's the end of that case. I honestly wouldn't be surprised if the court eventually orders a competency evaluation to determine whether he's mentally capable of representing himself. Now, let's move on to our next defendant, who apparently believes that everyone in the courtroom, including the judge, the court clerk, and even the court reporter, should recuse themselves from his case.
All right, Mr. Vaughn, we're here today because you have filed a number of different motions, and I want to address those motions with you, give you an opportunity to be heard. So if you want to come to the podium, since you are representing yourself, I will deal with each of those motions First of all, let me advise you that in April of this year, you sent a notice stating it was to the judge of record, stating that on the 15th day of April 2025, I have some concerns that I wish to speak to you about before I file papers in your court. I'm letting you know this isn't a request for advice. It concerns actions by your staff of the courts and yourself. With the utmost respect, I write this ex parte letter. If we can meet in private, I will. If I can't meet in private, I'll file it publicly and the order will be noticed. I could not speak with you privately because of the rules of conduct for judges. So the first notice or first motion that you have filed has been a request for a criminal record, and states that you're requesting the courts to move the state to furnish the defendant with a copy of prior criminal record per Rule 16 of Discovery and Inspection, Rules of Criminal Procedure. If I understand correctly, you're asking for a copy of your criminal record?
Yes, all them requests, the motion discovery is supposed to provide all that anyway, so that'll summing up half the motions. I mistakenly filed them separately.
That's fine.
Some of them.
You're entitled to discovery requests. Here, when you have a lawyer, a lot of times what will happen is the lawyer will be given access to the electronic system that the DA's office has implemented, where all of the discovery information, all of the evidence is loaded into an electronic system that then the defense lawyer can access that defense. Now, you don't have that ability representing yourself. So I'm going to order that all of the evidence in Mr. Vaughn's case needs to be put into written form, hard copies, and he needs to be provided with that.
Judge, the problem with that is going to be that there are videos from his arrest. One of his charges is retaliation for past action. And so there are videos from the officers in the jail at that time. And that's going to be one of the largest problems in providing that to him.
No, sir. That's not a problem. I filed a civil suit years ago. They provided me with the DVD, and it was my issue to deal with after that. And they allowed me to go into the office privately, view my own case, to fight my own case before, so that is not an issue.
Sounds like he's got it solved.
Okay.
You provide him with a DVD or a video on a compact disc. He'll access it as he needs to at the jail.
Okay.
All right, when is this going to be? Because I've been doing some of this since 2021. I'm tired of coming here looking at y'all. Like, this is going on for a minute. This is getting ridiculous. This is my first. I still ain't got a motion yet.
A motion?
I ain't got a motion yet. All the attorneys I had, all the public defenders I've had, nobody have provided me with nothing yet.
Okay. Well, I'm going to deal with all of that today, because you're going to get written discovery. You're going to get a copy of any videos so that you can look at them yourself. How long will it take for him to be allowed? His trial date's in September. How long will it take to get the hard copies of the written discovery? All right. We'll have it within.
Ben, she should have it today.
We'll have it within 10 days. Okay? You have a second motion, which is a motion to remove your counsel. Mr. Spratt was appointed as what is generally referred to as elbow counsel. You want to represent yourself, and I've granted you that opportunity. I've also appointed Mr. Spratt to assist you in representing yourself, so that he can, because you don't understand, I assume, the rules of evidence and the rules of criminal procedure fully as if you had been to law school. So having a lawyer who can assist you in making objections to evidence, for example, and things, that's the reason that you have elbow counsel. So Mr. Spratt was appointed, and he has tried a number of criminal cases, is very competent as an attorney, and that's the reason. So why do you want to dismiss your elbow counsel or your assistant
For
counsel?
one, the court doesn't respect the fact I'm pro se. They prefer to talk to him instead of to me. And anything should come through me first. He's an assistant.
Well, he's not your personal assistant. His role is to help answer procedural questions and assist you in navigating the legal process. If the prosecution or the court provided legal documents to him instead of handing them directly to you, it was most likely just a procedural formality and an efficient way to make sure you receive the materials necessary to represent yourself in a timely manner.
For two, Mr. Spratt, since December, has had a sickness or illness going on, which is on record in Humphreys County Jail, where he never could show up out there. I called 2 or 3 times. I should have had the motion discovery he just handed me.
All right, well, that's part of life, that people have illnesses and sickness. I am going.
Not for a month and a half. I'm sorry, sir. Excuse me, but not for a month and a half. I mean, he ain't able to help me.
Right. Well, I'm of the opinion that Mr. Spratt is able to help you with this because he is only elbow counsel. You're representing yourself. I will order that the discovery and motions that are filed in his court need to be sent directly to Mr. Vaughn rather than a copy to Mr. Spratt directly to Mr. Vaughn so that he gets a copy without having to wait for his co-counsel. No, you just have to mail it to him and he'll receive it. So I'm denying at this time your motion to remove counsel because I think it's important for you to have someone at trial to help you with that. I've ruled you're going to have access to the discovery directly. You're representing yourself. Mr. Spratt's role is as elbow counsel to assist you in, the trial itself.
Well, what about the fact that he couldn't even come to Waverly? How are you going to get to Decatur?
I'm going to appoint Mr. Spratt. You want to address any of that, Mr. Spratt?
I will, Your Honor. I'm not sure of what illness I had for a long time. I was sick back during the holidays. I did just hand Mr. Vaughn his discovery in case number 2021 CR 462. My understanding is the state wishes to proceed to trial in 2022 CR 336. There is no discovery that's been provided to me electronically for that case. When I did finally feel better and go to see Mr. Vaughn, he had been transported to West Tennessee, and I just simply have not been able to make it down there with my schedule. But he does have the discovery, or the written discovery. I did not give him the electronic discovery today because of reasons which he's now clarified.
Well, I told you that too when we talked on the phone. Me and you done been over that.
Let me hear from Mr. Spratt. This is not a time for you and him to discuss.
I mean, I'd be happy to mail him a DVD of anything electronic for that case that I have. I only have discovery for one case.
He needs the discovery for the case he's going to trial on, so let's make sure that that discovery is provided to him. Ms. Bryson says she can provide it to him next week, so I would order that she provide that by mail to Mr. Vaughn next week as he wants to have it directly, and then a copy to you, Mr. Spratt. All right. I am denying your motion to discharge Mr. Spratt from being your elbow counsel for the reasons I've stated on the record. Another motion you have filed is a demand for speedy trial. Your trial date is in September, which is the next term of court that I have. It's available, and for that reason, I believe that complies with the request for speedy trial that was filed. It is the first available date that we can put into play according to our rotation of judges and our schedule that we have. That is the first available day. The September date does, in my opinion, comply with your request. Case won't be continued, so we'll need to make sure that it is ready for trial on that day. The remaining motions that you have filed are all motions for discovery, which I think you had mentioned before, and I think we've now addressed that. So he's set for trial on September the 19th, is that correct? That needs to be shown to be first on the docket.
Excuse me, sir.
Docket, so that we'll go to trial. And let me address this. You filed a motion to recuse, notice of recusal or request for the master clerk, and you're asking to recuse or to somehow recuse the clerk of the court, and there is no basis that you have no standing under the law to ask this court to disqualify the clerk of the court. I understand your reasons for why you say that, and I have addressed the problems that you're saying you've had thus far with receiving copies of things, and that's going to be mailed directly to you. The court file will have it reflected that you are to receive all of those as lead counsel in your case. And I am not of the opinion that you have a basis in law or in fact to remove or ask for a recusal of the circuit court clerk. So that motion is denied. In addition to that, you had a motion to recuse the court recorder. And again, I have no idea why you would allege that there is a reason for that, but I don't find any basis for removal or that you have standing to remove the court reporter. She worked for me, and under that basis, I don't find there's any reason.
Well, then me and you have a conflict then, because you was on there doing the same thing they was doing. You want to put this on YouTube and not act a professional? Y'all want to make jokes in here? And then they don't want to file the paperwork? How am I going to get a fair trial here?
You're going to get a fair trial because you're going to be tried according to the law and the facts. And a jury of impartial people who know nothing about your case will make the decision.
So if I want to make an appeal and she ain't recording it, how are we going to do that?
She will be recording it if it is a felony case. There are certain times when the cases are not recorded, or if we're on break, it's not recorded. But
well, we wasn't on break because look, I just walked out the courtroom and I said something after we went on break. You said omitted, and she said, "Well, I ain't got to omit it." She said I wasn't recording no way. So how can I appeal something if y'all taking it out of the record without me being present during the proceedings?
First of all, I don't recall any such thing that
well,
you're
go back and look at the video.
I'm not required to go back and look at the video, Mr. Vaughn. I'm required to make decisions based upon whether or not you have standing for the motions that you filed. In my opinion, you don't have any standing to ask this court to discharge our court reporter or our clerk. And for that reason, I'm denying those two motions.
Well, recuse yourself because you're not doing it. You're not doing it.
And there's no basis for me to recuse myself.
Is this being recorded?
If you want to file a motion for me to recuse myself, then I will deal with that under Rule 10, and then I will address
I'm familiar with all the rules. Y'all sit me in jail long enough, best believe I read them.
While you're sitting there, you might want to spend some time reading the warning label on that box of jailhouse crayons, especially the part about not consuming the contents. Anyway, that's the end of that case. The rest of the hearing was just routine procedural matters before they escorted him back to his room at the Gray Bar Motel. Now, let's move on to our final hearing, which is easily one of the funniest probation revocation cases I've covered, and it comes from fan-favorite Judge O'Donnell.
Right, violation May 15th, positive screen for methamphetamine. You understand that charge?
Yeah, yeah. Sorry.
Mr. Fatica?
Good afternoon, Your Honor. I've discussed this violation with Mr. Davis. I anticipate that he's going to accept responsibility for his misconduct, waive the probable cause hearing and final hearing, and address the violation this afternoon.
Is that what you want to do?
Yes, Your Honor.
What's your plea to the violation?
I'm sorry, I couldn't hear you, sir.
What's your plea to the violation?
Guilty.
All right, I'll accept your guilty plea and find you guilty. So? What's the story?
Just trying to get back to the normal life, sir. I've been working 6 days a week, busting my butt, and taking care of my parents, and I just want to get back to work.
All right, that ain't what I said. That ain't what I asked you. What's the story? You're here for a violation for using it again. So what's the story?
I got high again.
Why?
Couldn't tell you. Stupid.
Well, why don't you figure out the answer so you quit coming back here every 3 months?
Yeah, you know,
Where'd you get it?
I really don't know. To be honest with you, I don't know.
What do you mean you don't know?
I don't know where I even ingested it from, but I'm not gonna say it wasn't dirty, because it was dirty. Obviously, I did take some. It just wasn't like my normally, when I do it.
Well, what do you
So-
normally do?
Normally, I'd smoke some, if I was gonna get high, I would smoke.
So how did you happen to get high this time?
I must have either ingested it or eaten it or something, but it was in my system. Doesn't take a lot to be.
You have no idea how that happened?
At this time, no. I've got some guesses, but
What's your
I'm not
guess?
denying that it was in my system. I mean, it was in my system, obviously.
What's your guess?
My best guess is this old cooler that I used.
For what?
An old cooler that I used to keep drugs in and stuff like that. I used it a couple of days for work. And then I actually just got a new cooler.
Well, have you figured out that cooler story yet, Chief? Because something tells me the drugs were in the cooler explanation falls apart for about a dozen different reasons. And judging by the look on Judge O'Donnell's face, he isn't buying a single word of it either.
I know it sounds crazy.
What was in the cooler?
At the time, I thought nothing, but
Well, I know, you said you had something in the cooler. What was in the cooler?
well, I just threw a bunch of food in it in the morning and some pops and stuff for the day and went about my day. So it could have been something in the cooler that leftovers from, when I was partying. But I'm not saying I didn't do it.
You don't expect me to buy that line of bullshit, do you?
Just
Do you?
telling
Do
what
you
I-
really?
No, I'm just telling you that's all I know. I
Okay.
didn't go out and smoke
Oh,
meth.
God almighty.
I didn't buy any, I didn't get any, I didn't have it and smoke it. I promise you, and I'm not trying to make it up. Last time I told you I did it, when I did it, I got it from a guy at the IOP. And the time before that, I got it from somebody at work, and I was doing it.
I've never heard that one before. It came out of the cooler.
No, I did it.
I know you
It's in my
did.
system.
Okay, you just don't want to tell me how you did it.
I didn't smoke it, I must have ingested it. So I ate some, I'll say. I know how it sounds crazy, and I know it sounds like BS, but I don't know what else to tell you. I didn't smoke it intentionally or anything like that, like I normally would. I am trying to get back to a normal life,
You've been in the old life.
and I'm working very hard.
Well, you're coming back here every 3 months for,
I understand.
so what effect did it have on you?
What, the court, or, I mean, the jail time, or actually, couldn't tell you, because I didn't really feel the effect. It used to get me amped up and feeling good.
Come on now.
What do you mean by what effect? I'm not understanding the question, sir.
When you were here a few months ago
Mm-hmm.
and you smoked, what effect did that have on your perception, on your, on what you were thinking,
I was
your
actually,
actions?
I was actually upset with myself and
No,
felt,
no. I mean, when you smoked them, did you get high?
yes, I used to, yeah.
So what did you do when you were, how did you feel when you were high?
Just energetic and good. I mean, the last time I did it, when I smoked it, I felt like crap. I felt depressed, I felt ashamed. And that was the first time I'd ever felt shame in my life over doing something that I used to do just for fun, But I did feel shame last time I smoked it.
Okay, when you had the after effects of the cooler, was the feeling the same?
No, because I really didn't feel it.
So you didn't get high at all?
Mm-mm. Not any kind of substantial high, no. That I remember, anyway.
What kind of cooler was it?
Just those like igloo coolers with it was a bag with like a liner in it.
So in what form did you used to put in the igloo
It
cooler?
had the front zipper part. I'd keep some, whenever I was doing drugs. I always had a cooler with me
In
at
what,
some
a
point.
liquid form or powder
No,
form?
it was in powder or crystals or whatever, little chunks.
But I would always throw stuff in there, in the little zipper part. There's a zipper part in the front to stay dry. That's where I keep cigarettes,
So when
stuff
you,
like that.
when you had the food in there this time in the,
I didn't think anything of it. I just.
well, I know, where did you put that? In the zipper part or in the
Yeah,
cooler
I
part?
threw a couple sandwiches in in the zipper part and threw some ice and a couple Pepsis in the cooler part.
Why didn't you put the sandwiches in the cooler part to keep them?
Because then they get soggy. I mean, I only used it for a couple of days because I needed to get a new cooler anyway. It was an old cooler. It just needed something for those couple of days to get through the day because it was warm days. I wanted some pops I was going to be gone all day.
How big is the zipper container?
It's big enough to hold a couple sandwiches and some cigarettes.
You seriously can't make this stuff up. He literally described the pocket as being large enough to hold 2 sandwiches and a handful of cigarettes. Keep in mind, according to his own story, those sandwiches weren't wrapped in anything because that's supposedly how he accidentally ate the drugs. And he didn't even mention a cigarette pack, which means we're apparently supposed to believe the loose cigarettes were just rolling around in the bologna and mayonnaise while he pulled them out one by one throughout the day. If that's the story he's sticking with, it's no wonder nobody in the courtroom is buying it.
It's so cool. It's like a bag
I
cooler.
mean, the more this conversation goes on, the less I believe it. I didn't believe it from the start.
I don't know what else to say.
So you're a guy that, once again, you're how old now? 53?
53.
53. You didn't start using drugs till you were 47.
When I lost my everything, yeah. Kind of went down
At
the hill.
least as far as the record shows, which is
Right.
probably a good bet. Okay?
No,
And then-
that was when I started, when I got divorced and my wife left me after 22 years.
I know, but
spiraled out of control.
it's probably not a situation like you were using since you were 20 until
No, I really
all of a
wasn't.
sudden you got caught at 47. You probably weren't using, otherwise, because you ain't very good at this stuff.
No, I'm terrible at it. I'm the worst criminal.
So you get 4 convictions, all in 19, all in December of 19.
Yeah.
Then you get nothing until February of 24.
Yeah, I'm not very good at this
And
criminal.
so what kind of drugs was that in February of 24?
It was everything was.
Okay, so then you get sentenced on that in September of 24. Then you got a violation, you're here again in, 2 weeks later? Is that what that was, Dave? Like 2 weeks?
The first one, yeah.
Yeah, he was sentenced September
18th,
18th,
right?
And we filed on him October 3rd.
And when was the use from?
He had tested positive
From-
first time on a sample he submitted on September 23rd.
Okay, so 5 days after you're sentenced. And then, you come back in November 20th, and I keep you on probation. You did 52 days in jail. So you get out, and then when's on the next affidavit, when was the date of the positive test?
That one was submitted on January 16th.
January 16th, so about 9 weeks later, after you get out of jail, you're doing it again. So on February 19th, we get that one cleared up. And 3 months later, you're doing it again. Although you're not really doing it again,
Then
right? So, what am I supposed to do with you, who just won't quit doing what you're not supposed to do?
just want to go back to work, sir.
Just want to go back to work.
Just want to work and get my life back.
It's the 4th time I've heard that from you. You just want to get back to work.
I'm working though. I am working.
Yeah, but then you're using too.
I understand.
You're working and using,
I understand.
and you're in jail.
I understand.
How long have you been sitting in jail this time?
Since Thursday.
So did you go to that Rosary Hall IOP a long time ago?
Yes, sir.
2 violations ago?
That's when I got violated coming home with, that's when I got high coming home with somebody from there. But I'd be definitely willing to give any IOP another shot. I would love to.
Why? If you just, it was all by accident, why would you need treatment?
I don't know what to say.
You got any suggestions here, Mr. Fatika? Because this is a mystery.
Your Honor, he's been consistent with me. He just wants to get.
I know he has. He's been consistent here, but he's been consistently lying since I've been in here. So, is this a guy who needs treatment or doesn't need treatment? Because he really hasn't consciously done any since November. So he's been free except for the cooler for 8 months, 7 months. So what's the point?
I don't know which one to say, sir.
I don't know, say anything you want to say, okay, but, you know, blaming it on the cooler ain't working.
No, I know.
So you got a problem or don't you got a problem?
I mean, I guess I have a problem.
Okay, you guess. So going back to work isn't gonna cure the problem because you were going to work and using, right?
Well, I mean, I think I'm able to kick this. I know I am.
No, you're.
I just need to stay busy, and that's what I've been doing. I know it didn't work, but whatever. I'd like another shot to at least prove to myself that I can do this. I'm going to AA. I go to 4 meetings a week of AA. I've been doing that religiously. I got a home group. I enjoy those meetings.
Well, what good are they doing?
They're keeping me focused. I'm a good man, sir. I've had some problems, and
I'm not opining on whether you're a good man or a bad man, okay? I'm saying you got a problem that you don't think you have, okay? Because you've only done it like 3 or 4 times, okay? But you didn't do it this time, okay? And you're telling me all you gotta do is work and stay busy, but you were working and staying busy and still getting high. So that's not accurate either. So it's got nothing to do with you being a good man or a bad man, okay? I'll accept the fact that you're a good man because the only trouble you have is 8 days in December of 19 and this shit that started up last fall. That's the only problems you've had. So the question becomes, how do we keep Brian Stavis from coming back here every 3 months? And it ain't by just going to work and staying busy,
I understand.
because it ain't working.
I understand. I mean, I've done NeoCap, I've done all that stuff, that did help. I mean, I got 2 years clean after that, but I relapsed, and I mean, if there's a treatment you want me to do, I mean, I guess we'll give it a shot. We're looking, I've got a lot of open work to do that I really need to get to, but I mean,
Yeah, well,
I got cabinets, I got a whole woman's kitchen in my garage getting
Yeah.
cabinetry done.
Jesus. Then
Nothing I can do about
you
it.
shouldn't be out there smoking.
I get that, I get it.
Where were you going to AA meetings?
I go to a meeting on Wednesday night is at First Presbyterian Church on Route 91 in Mayfield, or Highland Heights. And I go to, my other one is at, there's 2 at Lyndhurst, First Baptist Church.
Who's your
One's a
sponsor?
Sunday and then one's a Saturday. What's that?
You got a sponsor?
I do not have a sponsor yet, no, but I do have a home.
Why
group.
not?
I just haven't found the right person yet.
What, well,
I mean, I'll get
I
one.
mean, were you looking at all because
Yeah.
you were?
Originally I had one, but he's not going to the same meetings as I go to all the time, and he doesn't, I haven't seen him in a while, so I just kind of didn't even mess with him. But I mean, I've been looking at one guy I've been talking to, I'm gonna probably end up making him my sponsor, he's in my home group.
You sound like the kind of guy that's gonna do, and you don't do.
No, I actually have, man, I go four meetings a week, so, and I've been enjoying it. My home group is one of my favorite nights of the week. It's Wednesday night. It's a good meeting. It's open book, a lot of conversation. And the guy I've been talking to that I think is gonna be, he's been sober for 40 years, so. And he's sponsored a lot of people, so hopefully he's willing to take me on and.
Oh yes, there is. It's called telling the truth. Judge O'Donnell may have a colorful personality, but he's also known for showing compassion to defendants who take responsibility for their actions and are genuinely remorseful. On the other hand, when someone shows up with a story that clearly doesn't hold together, like blaming everything on a cooler, he's far less likely to be persuaded. So, let's see what sentence the judge decides to hand down.
I know it doesn't seem like it, but I do want to be sober, sir. I want to stay clean. I want to get my life back. I really do.
I would assume so,
I really do.
since you keep ending up in jail.
I promised myself last time that I was never going to be in these again, and I failed. And I let myself down on that, and I don't ever intend on doing it again.
Okay. I would guess that 95% of the people that walk out of here at the end of the hearing never intend on doing this again.
I know. I
And
get it.
of those, probably 90% come back having done it again.
I understand. And I'm one of
So
them.
just wanting to not do it again doesn't mean you're not gonna do it again.
I understand.
So it seems to me that these meetings haven't done you a lick of good because you're not utilizing whatever you're supposed to get from them. And you didn't get a sponsor because you just didn't see fit to get a sponsor. That's why you didn't get a sponsor.
Well, I mean, you have to, the program is 12 steps. I'm just starting out. I'm going on the steps. I wanted to get some meetings in. I've talked to people. I've been going. I've been doing extra stuff with them. Just wasn't ready to get a sponsor.
Everything you're doing is right on the surface.
Yeah.
The people who are on the surface keep coming back. The
Well,
people
that's
who
what
dig, trying to figure out why they're doing what they're doing, are the ones that are less likely to come back.
I get it. I get it.
I mean, your whole thing now for the fourth time is you just want to get out, and go to work. That's what you want to do.
But I want
This
to
is the fourth time we've had the same conversation now.
I want to have the program. I want to let the program sink in. I want to get in. I want to submit. I want to surrender myself to the whole program. And I plan on doing. That's what I'm doing. That's my goal.
Okay, that may be, that may sound good, but you coming in here and telling me that you got them from the sandwich in the cooler.
Listen, I understand. No matter what I say, I understand. Doesn't sound right. Doesn't sound good. And there's nothing I can say that's going to change your mind. So.
All right, everyone, that's a wrap for today's video. Every one of these cases, except for the last one, should have a follow-up hearing that I'll be covering in a future upload. Considering how each of them played out, I'm definitely looking forward to seeing what happens next, and I'll be sure to keep you updated. Also, be sure to head over to Cool and Mac Olive's channel and give them a subscribe. If you enjoyed today's video, hit the like button. If you didn't, feel free to hit the dislike button, but don't forget to leave a comment below and subscribe with notifications turned on so you never miss any of my future content.
Where's the cooler right now?
Garbage. I threw it away.
Huh?
I threw it away when I bought a new cooler. I needed a new cooler anyway. That thing was old and beat up. I just used it for a couple of days just to get by till I got my paycheck. And then I bought a new cooler and some other extra clothes and another pair of boots.
All right, you're gonna stay on community control. You're gonna serve 50 days with credit for 5. You're gonna get into the jail treatment program at the earliest possible date. Make sure that we check on that, okay?
Yes, sir.
And then follow all the recommendations. If you get in earlier than the 45, then the rest of the time will be suspended. Go into at least 4 AA meetings a week and get a sponsor.
Gotcha.
Stop with the process of getting a sponsor, and let's go with getting a sponsor.
Okay.
Maintain full employment. Do you have anything else?
No, sir.
If you don't get honest with yourself, you're gonna keep coming back here. And eventually, you're not gonna come back here
I get it.
because if you don't get straight with yourself, then there's only one thing left to do. Anything else, Mr. Fatico?
No, thank you, Your Honor. Thank you, Your Honor, I appreciate it.